David Cruz.
Good morning, sir. Can you tell me your name?
David Cruz.
Counsel, can you put your name on the record?
Michael Zemieski on behalf of Mr. Cruz.
Mr. Cruz, you are here in case 2021 MM 496AW on charge of battery domestic violence. They reviewed the charging affidavit in your case. They did find probable cause for your arrest. I'm going to set your bond in that case in an amount of $3,500. Condition of your bond, you had no contact with the victim in that case. You are to maintain a separate residence from that victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. The weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. And are you representing him in the new case or both cases?
Judge, I have not filed a notice yet. He will be in contact with me once he's released. I also want to let the court know that the alleged victim in that case is also on your first appearance list this morning, but it looks like she may have refused to come over. Jessica Houtz.
Oh, I had a Jessica House this morning. Let me see.
Yeah.
Yeah, there it is. Yep. She back there?
Yeah.
I'll deal with her in a minute.
So
All right, we'll get to her in house. All right, and that's also case 2021 MM 497AW. I want to appoint a public defender to represent Ms. House.
I'll waive the appearance.
All right. I also did find probable cause for battery domestic violence as to her as well. I'll set her bond in the amount of $500. It's going to come with pretrial release supervision. She's having no contact with Mr. Cruz in this case. They're to maintain a separate residence from each other. Whose name's on the lease?
Her name.
So you allow her return back to the residence. She not possess any weapons or firearms. The weapons or firearms she has need to be turned over to law enforcement within 24 hours of the release. All right, you just got to order. I think you got to write on there she can return, because otherwise they're gonna. Yeah, she can return to the residence.
I just didn't want there to be confusion with that.
No, I got you. All right, did you want to tell me anything else before I address this other case?
No, Your Honor.
All right. Mr. Cruz, you're also here in 2021 CF 7377AO for a failure to appear warrant. Judge Blackman, I spoke to him this morning. He told me to modify that bond in that case, set your bond at none. Your bond's going to remain at none in that case. You have Mr. House representing you in that case. Still conditions have no contact with the victim in that case.
And just for record, it wasn't a failure to appear. It was based on a new arrest that ultimately the bond was revoked in the case. There's not been a filing decision on that case.
On the there's a failure to appear warrant I'm looking at right now in case 2021 CF 7377AO. The case was filed. I think I looked at it this morning. I'm not losing my mind. Somebody pull it up real quick.
Because we filed a notice of appearance, we've not been notified of any.
Oh.
Right, it was based on a new arrest issue, so that's why that was.
Oh, another arrest?
It should have been an out on bonds, like revocation, Your Honor.
Yeah,
The
it's-
information hasn't been filed.
It's not a failure to appear, I just.
Okay, oh, okay, all right. So, sorry, the judge issued a KPS based on Florida statute, I believe 903 point, is that 0471? So you commit a new law offense?
We'll have to go back to court.
I don't release in that case.
Yes, Your
So
Honor.
that bond has been revoked, Your Honor?
The bond set at none.
Okay,
It was already revoked. He just modified the bond amount to none.
to 2,000 and then revoked it again, I guess.
Guess not really technically revoked it, but I didn't say, I said it's modifying the bond amount. So you just didn't revoke it, just modified the amount.
From 2,000 to none.
Correct. Yep, correct. All right, everybody have a great day.
Thank you, Judge.
Coming up, coming up, coming up.
Good morning, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has been previously sworn, Your Honor.
Good morning, Mr. Laurel. I have a defendant at my lectern. Could you see if you could make a connection with this podium?
The interpreter is connected to the podium, Your Honor.
All right, good morning, sir. Can you tell me your name?
Caney Feliciano Rodríguez.
Ani Feliciano Rodriguez.
Mr. Feliciano Rodriguez, you are here in case 2021 MM5349AO on charge of battery domestic violence. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Going to set your bond in this case in amount of $500. Conditioning your bond be subject to pretrial release supervision. You to have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this case. You have a great day, sir. Good morning, sir. Can you tell me your name?
Brian Polanco Jiménez. Sí.
Rey Polanco Jiménez.
Is your name Brian Polanco? Well, or is it? Say your name again.
Brian Polanco Jiménez.
Interpreter is getting Polanco Jiménez. Polanco is Polanco.
Yep. His first name is Brian, correct?
Sí.
Yes.
All right. So you're here in case 2020 CF 14874AO for a violation of probation. Judge signing your warrant in this case set your bond at none. Your bond's going to remain at none in this matter. We're going to appoint the public defender to represent you in this case. You have a great day, sir.
¿Pero prueba de qué? ¿Prueba de qué? ¿Revocación de prueba de qué?
You mean that my probation has been revoked?
Yep, you've been violated for probation, for violation of probation. All right, have a great day, sir.
¿Cómo la violé?
How did I violate my probation?
The judge signed your warrant in this case saying that you failed to report as directed on July 9th of 2021 to the probation office on July 12th, 2021. So you didn't go to probation on time.
¿Por qué?
I'm guessing.
Porque estaba preso. No, nunca salí de aquí.
Because I was in jail. I was never out of here.
He's been in custody since May the 26th. They placed him on probation while he was in jail. He's never been released.
What was he in jail? What, you put him on probation?
While he was in jail.
Correct.
He's never been released since May 26th, 2021.
On what? That's what I'm trying to.
He was in here on possession of cocaine, resisting officer without violence, and possession of drug paraphernalia, which was a remote case. But I think he originally came in on,
I have some new cases. That's the honest thing.
I trespass and occupied structure, stalking, and criminal mischief on May 26th.
So he's,
Sí. 26 de mayo.
Yes.
when was he
Yes,
placed
May
on?
26.
He was placed on probation on July the 9th, 2021.
Let me see his criminal history. Yeah. All right, Mr. Jimenez, I'm gonna based on the information, I'm gonna RR you as to this violation of probation. However, it's nonsensical that you took a probation officer offer while you were in jail. That just sounds good. All right, have a great day.
Ok, gracias.
Okay, thank you.
All right, that was my last case, correct?
Yes.
All right. Thank you, Mr. Interpreter. Have a great day.
Do your honor.
Good morning, ma'am. Can you tell me your name?
Cynthia Baez West.
Ms. Baez West, you're here in case 2021 CF 916162, AO on charges of possession of fentanyl, possession of controlled substance, child abuse, possession of drug paraphernalia in 2 counts. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Going to stay your bond, count 1, amount $1,000, count 2, $150, count 3, $5,000, count 4, $100, and I'm going to RR you as a count 5. Condition of your bonds that you're not allowed to possess any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing at your expense. You also to have no contact with the alleged victims in this case and have no unsupervised contact with any child under the age of 18 years old. Now, question I have for the state of Florida and for PTR or the jail is that I read the report, but I didn't see that DCF was contacted.
You scanned the phone?
So I just want to know, did that happen?
I can reach out to the officer, Your Honor.
Well, if so not, then can you want to order that the state mandatory, like, do you contact DCF about this case? They have not already been contacted.
They have been.
Huh?
They have been.
Okay. All right. Going to appoint a public defender to represent you in this case. You have a great day, ma'am.
I'm sorry?
I'm going to appoint a public defender to represent you in this case. You have a great day. Good morning, sir. Can you tell me your name?
Keon Brooks.
Mr. Brooks, you're here in case 2021 CF 8522 on a charge of battery, domestic violence by strangulation, aggravated assault with a firearm, and criminal mischief. I did review the warrant signed in this case where the judge already found probable cause for your arrest. I'm going to set your bond in count 1 in the amount of $1,000, count 2 amount of $3,000, and count 3 in the amount of $500. Condition of your bond that you had no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return if you have a shared residence with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this case. Do you have any questions about your no contact order? Have a great day, sir. Good morning, ma'am. Can you tell me your name? Ms. Ellis, you're here in case 2021 CF 9119 AO on charge of aggravated assault with a deadly weapon. I did domestic violence. I did review the charging affidavit in your case. I did find probable cause for your arrest. I'm going to set your bond in this case in the amount of $2,500. It's going to come with pretrial release supervision. You to have no contact with the victim in this case. You are to maintain a separate residence from this victim. If you have a shared residence, I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this matter. Do you have any questions about your no contact order, ma'am? No. Have a great day, ma'am. Good morning, sir. Can you tell me your name?
Gustavo Gomez.
Mr. Gomez, you're here in case 2021 CF 9163 AO on charge of aggravated assault with a firearm, domestic violence, possession of, what is this? Psilocybin? Maybe?
Psilocybin?
Maybe. Psilocybin? I've run across that one before. All right, possession of THC oil. Possession of cannabis with intent to sell and deliver, possession of cannabis, felony possession of cannabis with a weapon, carrying a concealed firearm, and possession of a controlled substance, and possession of drug paraphernalia. Got it all. Good morning, ma'am. Can you tell me your name?
Chanel Cordero,
Can you spell your last name?
Cordero.
All right, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, you put your hand down. All right, ma'am, can you tell me how you know Mr. Gomez?
My boyfriend.
Say again?
My boyfriend for like the past 3 years.
And do you want to have contact with him while this case is pending?
Do I want to?
Yes.
I filed an injunction yesterday.
All right. Would you happen to know the injunction case number?
No, not yet.
All right. The drug use in this case, is a drug use or alcohol a problem in this case?
He has an alcohol problem.
All right, Mr. Gomez, as to count one, the court is going to set your bond in the amount of $8,000. Count two, $150. Count three, $150. Count four, $150. Count five, $150. Count six, $150. Count seven, $150. Count eight, $100. And count nine, $100. Condition of your bonds.
Your Honor, count 10?
Sorry. And sorry, and one more 100.
I also have the case number for the injunction, Your Honor, if you would like it.
All right, was the temporary injunction granted yesterday, or is it still being reviewed?
There was a temporary final hearing injunction.
While State's looking at that. Mr. Gomez, you have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at any shared residence. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You also may not possess any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing at your expense. I want to appoint the public defender to represent you.
Your Honor, there is a temporary injunction that was ordered on August 3rd.
All right, case 2021 DR.
9401.
Make a condition of your release that you comply with your injunction in case 2021 DR 9401. All right, Mr. Gomez? Now, I'm going to tell you right now, you can probably speak to a lot of people on the way out of here. Don't violate these orders. You understand that?
Yeah.
You violate these orders, it's going to be a really long day, bad day for you. You understand that?
Yes.
All right, have a great day. All right. Good morning, sir. Can you tell me your name?
Christopher D. Griffin.
Mr. Griffin, you're here in case 2021 CF 7958 on charge of aggravated battery causing great bodily harm. They reviewed the charge, there's a warrant in this case. The judge already found probable cause for your arrest. Going to set your bond in this matter in the amount of $10,000. Condition of your bond is you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this matter. Do you have any questions about your no contact order?
No, sir.
All right. Now, looking at your history, not sure if in any of these cases you had the opportunity to do a batter's intervention course, but you may want to enroll in one.
I can hardly hear you.
I said, I don't know if any of these other prior cases that you had the opportunity to do a batter's intervention course, but you may want to enroll in one of those batter intervention courses. It might keep you from seeing me more often. Okay?
All right.
Have a great day. Yeah, no. I wish I could order it. If I could, it would be, change my life. Good morning, ma'am. Can you tell me your name?
April Mendiola.
Ma'am, you're here in case 2021 CF 9165. AO in charge of possession of fentanyl and child abuse and possession of drug paraphernalia. I did review the charging affidavit in this case, did find probable cause for your arrest. Set your bond in count 1 in amount of $1,000, count 2 the amount of $3,500, and count 3 going to stay the amount of $100. Condition of your bonds is you to have possessed no drugs and alcohol without a valid prescription. You are to be subject to random drug and alcohol testing. You may not have any contact with the victims in this case. And you may not have any unsupervised contact with any other child under the age of 18 years old. I'm going to appoint the public defender to represent you in this matter. If you have any questions about your no contact order?
No, Your Honor.
All right. Have a great day. Good morning, sir. Can you tell me your name?
Zachary Jerome.
Mr. Prone, you're here in case 2021 CF 9166 AO on charges of aggravated battery, alternatively domestic violence, false imprisonment, domestic violence, grand theft, and criminal mischief. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Going to set your bond in count 1 in the amount of $10,000, count 2 in the amount of $2,500, count 3 $500, and count 4 $500. Condition of your bonds that you have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this matter. Do you have any questions about your no contact order?
No, sir.
All right. Have a great day, sir. Oh. Hold on, somebody said you didn't qualify. Hold on, wait a second. 1 second. No, I want to point. I'll point the public defender to represent him.
So no PTR, Your Honor?
No, I won't point the public defender.
Okay.
Good morning, sir. Can you tell me your name?
Mr. Never White.
Mr. White, you're here in case 2021 CF 90710 on a charge of tampering with a witness to hinder communication of law enforcement and battery domestic violence. They reviewed the charging affidavit. Sorry, there's a warrant in this case. There's a judge signing a warrant in your case, finding probable cause for your arrest. Going to set your bond in count 1 in the amount of $1,500 and count 2 in the amount of $500. Condition of your bonds is that you have no contact with the victim in this case. I'm going to strike the no return and say maintain separate residences. I'll give you a one-time return if you have a shared residence with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned over to law enforcement within 24 hours of your release. You also may not possess any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing at your expense. I'm going to appoint the public defender to represent you in this matter. Do you have any questions about your no contact order?
You said I can return with a law enforcement. I've been with this woman for 34 years.
Yep.
Okay, so. All right.
Oh, what does that mean? Are you asking me, or I'm trying to understand what you're asking me?
I was asking, you said, I was reaffirming what you said. If I go back to get my stuff, I have to go with a law enforcement.
Correct.
Okay.
Don't go without them. You will be arrested, and I will see you very soon.
Okay.
Have a great day.
Good morning.
No, I pointed. Because y'all, with this affidavit, y'all put it.
What did he say? That one. Oh. I just said.
Good morning, ma'am. Can you tell me your name?
Good morning. My name is Anasia Bennett.
Ms. Bennett, you're here in case 2021 MM5363 AO on charge of battery dating violence. They reviewed the charging affidavit. In this case, they find probable cause for your arrest. Going to set your bond amount of $250. It's going to come with pretrial release supervision. You're to have no contact with the victim in this case. You are to maintain a separate residence from this victim. If you all have a shared residence, I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this matter. If you have any questions about your no contact order. All right, have a great day, ma'am.
Thank you.
All right, good morning, ma'am. Hello, there you go. You can tell me your name, please.
Rebecca Henderson.
All right. Ms. Henderson, you're here in case 2021 MM338AA on a charge of battery. They reviewed the charging affidavit in this case. They find probable cause for your arrest. Good morning, sir. Can you tell me your name and spell your last name?
Ocasio Lyons, Lyons.
And can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You put your hand down. All right, sir. Can you tell me how you know Ms. Henderson?
Through a friend.
Can you?
Through a friend.
All right. And do you want to have contact with her while this case is pending?
Yes.
All right, you got a look at echo going on. Say it again.
Yes.
All right. And has there been previous instances of domestic violence between you all in the past?
No.
Did drugs or alcohol play a role in this particular instance?
No.
All right. Say, you got any questions for the witness?
No, Your Honor.
All right, Ms. George.
No, Your Honor.
All right, Ms. Henderson, I'm going to release you on pretrial release in this case. Conditions of your pretrial release that you have no hostile contact with the defendant and the victim in this case. Now, no hostile contact means this. You can be upset with him. You can be upset with him that he's left the toilet seat up, made a mess he didn't want to clean up, left a shirt right outside the hamper instead of putting it inside the hamper. All those things that happen in a relationship that cause like conflict. However, those disagreements cannot turn violent. They cannot turn threatening. There can be no abusive language used. Because if he calls law enforcement, or somebody that sees or hears you all arguing, calls law enforcement, you will be arrested. You'll spend the remaining of your time here with me on a no bond status. You understand that? You also may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm also going to appoint the public defender to represent you. You have a great day, ma'am.
R&O. I've been released for R&O.
All
Nope,
right.
you're on pretrial release, ma'am.
Oh, PTO.
Good morning, sir. Can you tell me your name?
Huh?
Can you tell me your name?
Irvin Snowell.
Mr. Noel, you're here in case 2021 MM5348 AO on a charge of battery domestic violence. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Going to set your bond in this matter amount $250. It's going to come with pretrial release supervision. You're to have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this matter. Do you have any questions about the no contact order in this case? All right, make sure you abide by my orders. Have a great day. Good morning, ma'am. Can you tell me your name?
Gloria Serrano?
Mr. Serrano, you're here in case 2021 MM498AW on the charges of battery and domestic violence and stalking domestic violence. I did review the charging affidavit, did find a factual basis probable cause for the charges. Good morning, sir. Can you tell me your name and spell your last name?
My name is Francisco Alvarez, and last name is spelled Alvarez.
And can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes,
You put your hand down. Can you tell me how you know Ms. Serrano?
that's my girlfriend.
Do you want to have contact with Ms. Serrano while this case is pending?
Yes,
Has there been previous instances of domestic violence between you all in the past?
no,
Did drugs or alcohol play a role in this incident?
no, sir.
All right. So, question for you.
Sure.
How often do you guys have these kind of disagreements?
Not often. It's just there was a disagreement yesterday. Things got a little heated, and I basically jumped out the truck. She was just trying to talk to me and stuff like that. But as far as what they reported in terms of the battery, that never happened. She just put her arm behind my back, and I guess they seen it on camera, and they thought that was a battery. She was just, saying, let's talk. Wasn't nothing more than that. It wasn't a hit or a touch or anything. In the bag situation that they reported as well was just me releasing my bag to her. She didn't snatch it or pull my arm or nothing like that. Just gave her the bag and asked for it back.
Well, my thing is this. If I order no hostile contact, I don't know if you were paying attention a few minutes ago. Somebody interprets what they believe to be threatening.
Sure.
She's going to be arrested.
Understood.
You understand that?
Yes.
All right. All right. So, Ms. Serrano, you weren't here for my earlier discussion. So I'm going to do this. In count one, I'm going to set your bond amount $250. Count two, $250. It's going to come with pretrial release supervision. You're going to have no hostile contact with your boyfriend. All right? I understand. You guys have a relationship. You can be upset with him. Be upset with him, you left the toilet seat up. That he's not helping you take care of the baby. That he's not feeding the baby or changing the baby or assisting you in the way that you want to be assisted. However, those disagreements cannot turn violent. They cannot turn threatening. There can be no abusive language used. Because whether he calls law enforcement or like what we were seeing in this case, if somebody sees or hears you all arguing, calls law enforcement, you're going to be arrested. You're going to be staying here with me at the Orange County Jail on a no bond status. You understand that? You also may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this matter. You have a great day, ma'am. Have a great day, sir.
Thank you, Judge.
Good morning, sir. Can you tell me your name?
Josh.
Sir, you're here in case 2021 MM 5365 AO on charges of domestic violence, battery, and criminal mischief. They reviewed the charging affidavit in this case, did find probable cause for your arrest. I'm gonna set your bond in count 1 in the amount of $1,000, count 2, $500. Conditional your bond that you have no contact with the victim in this case. You may not, sorry. You must maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release.
I hear you, sir.
I'm going to appoint the public defender to represent you. Now, were these past DV cases with the same victim? Well, I'm doing, and also state that you make an offer as his out on bond case. 2021 CT 472 AW.
I got it. It's just, they didn't put it
I want to guess so based on the charging affidavit, but
It's not uploaded into our case management system yet.
all right. Well, I'm going to say based on the statements in the charging affidavit that it is. All right. Now, so the next question, did you make an offer as to the driver license suspended case?
It was an NTA.
Your Honor, on his out on bond, his driver while license suspended, it looks like the judge actually granted, the motion to D6 clearance. He's actually made an appointment with the, DMV to pay his fees, to get his license reinstated. So they were actually working with him to get his license reinstated. The court was. So I just ask that you can take that into consideration. And because he's setting up that appointment to work with the court, I'd ask that if you are inclined to revoke his bond, that you revoke in double so that he can take care of that issue.
Otherwise, the offer was an adjudication. But in this case, there's already been prior failures to appear, so state would ask that you revoke and double Judge Wallace.
All right, Mr. Streeter, in 2021 CT 472 AW, of course, is going to revoke that bond based on the probable cause that you committed a new law offense while you're out on bond. We'll set a bond amount of $4,000. Condition your bond, you not operate a motor vehicle without a valid driver's license. Now, you can squint your eyes and look at me, but you seem to have a problem following orders. So don't violate my orders. I promise you, don't do it. All right? So don't violate your no contact order. Listen to me. Go that way. See? Following directions.
Do you want to know if the other cases were the same victim, Your Honor?
No, his DV case got to go to Division 50.
There was a 2016 misdemeanor bat DV. Victim was Miss Holly. There was another 2016 misdemeanor bat DV. Victim in that one also being Miss Holly. There's a 2015 bat DV, victim being Miss Holly. There's another 2015 bat DV criminal mischief. Victim in that one also being Miss Holly.
All right. Have a great day, sir. All right, I had Carolina. Varela?
Eduardo Bonded, Your Honor.
On to VOPs. Good morning, sir. Can you tell me your name?
My name is Parker.
Sir, you're here in case 2016 CF 9262AO for violation of probation. Judge signing your warrant in this case set your bond at none. Your bonds will remain at none. Going to appoint the public defender to represent you in this matter. You have a great day, sir.
No bond. You have no bond. You gotta wait.
All right. Yep, you're gonna be seen by Judge Lattimore in a few days, down the next two courtrooms down for arraignment. Have a great day. Good morning, sir. Can you tell me your name?
Travis Hill.
Mr. Hill, you're here in case 2017 CF 10849AO on a violation of community control. Judge signed your warrant in this case, set your bond at none. Your bond's gonna remain at none. You're a violent felony offender of special concern, sir. You're not gonna be entitled to release on this case until your violation of probation goes to hearing. I want to appoint the public defender to represent you in this matter. You have a great day, sir. All right. Good afternoon, sir. Good morning, sir. Can you tell me your name?
Good morning, Christian Oliver.
Mr. Oliver, you're here in case 2021 CF 9148AO for a charge of felony possession of cannabis. Possession of cannabis with intent to sell and deliver. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Gonna set your bond in each count in the amount of $500. Condition your bond that you do not possess or consume any drugs or alcohol without a valid prescription. Not associate yourself with any known drug dealers or drug users. However, you're on probation in case 2020 CF 505. Law enforcement filed an on-view violation of your probation. Going to stay your bond at none in that case. Because you're a violent felony offender of special concern, sir, you're not entitled to release on this violation of probation until your violation of probation goes to hearing. We want to appoint the public defender to represent you in both cases. You have a great day, sir. Good morning, sir. Can you tell me your name? Mr. Williams, you're here in case 2019 CF 9515 for a violation of probation. Judge signing a warrant in this case, set your bond at none. Your bond's going to remain at none. Going to appoint the public defender to represent you in this case, not taking any action on this 2020 CF 13533AO case. You have a great day, sir. All right. Yep. So yesterday, I guess apparently some 33 motions were entered in error. First one being
Good afternoon. Please tell me your name. I'm sorry, did you say Donald Harris?
Yes, ma'am.
All right. Sir, you're here in 21 CF 9074 because a warrant was issued for your arrest for written threats to kill or do bodily harm. Another judge has already found probable cause in this case. I'm going to appoint an attorney to represent you. Does the state wish to be heard on bond?
Your Honor, I would just ask for a bond that's reasonable given the nature of the offenses and his prior history.
All right, Ms. George, did you have anything to add?
No, Your Honor.
Is he currently out on bond and on other charges?
There is a misdemeanor non-arrest, but it's a non-arrest case, so he's not out on bond for a violation of a domestic injunction. He has a 21 violation of a domestic injunction, and he appears to be out on bond on a burg dwelling, that one prior DV. That's 21 CF 2564.
Is he on pretrial release?
Already. I'm sorry?
Is he on pretrial release? It says that he is.
Prior, but when he saw Judge Bain, We were trying to figure that whole thing out, but those charges she's speaking of, they are to revoke those charges.
Okay. All right. Thank you for your patience, sir. I'm just trying to understand all the notes that I'm seeing here on the paperwork. All right, at this time, your bond is $15,000. You can have no contact with the victim. Do you understand what no contact means? You have to answer out loud.
Oh, yes, ma'am.
Even while you're in custody, you can't call her on the phone, you can't send a message through friends or family members, you can have no contact. You can't return to the scene, you can't possess a weapon of any kind, firearm or ammunition, you can't be within 1,000 feet of her place of residence or place of employment. Do you understand that?
That's what, she works at the courthouse, where I went to court at the other day. And that's
Don't
what-
talk about
Oh, okay.
But you're saying she works at the courthouse? You have to answer out loud.
Yes, ma'am.
All right, then you can't be within 1,000 feet of her place of employment unless you have a court ordering you to be there. So if you have a court date, you have to go to the courthouse. You understand? You have to answer out loud.
Yes, ma'am.
All right, Ms. George, can you put a note so that your colleague, whoever gets assigned to that case, can make sure that he understands that? I don't want him missing a court date and then thinking that this order prohibits him from doing that.
Yes,
So you understand, when you have court, you have to go. But if you don't have a court date from a judge, you can't be at the courthouse.
Can I ask you something?
Yes.
What could I do about this $1 million bond on this misdemeanor charge I have?
I'm sorry, say that one more time, just get closer to the microphone.
What can I do about this $1 million bond on this misdemeanor charge that I have?
I don't know anything about that. Did Judge Bain set that bond?
$1 million?
You have to answer out loud.
Yes, ma'am, $1 million on a misdemeanor, that's ridiculous.
Well, sir, I'm looking at your history, and I'm sure Judge Bain was as well.
$1 million though, that's not even giving me a chance.
So the judge has to weigh a lot of things when setting bond. I wasn't there when Judge Bain did that, but what you can do is call your attorney and ask them to set a motion to reduce your bond in front of the trial judge. I'm not going to do that today.
Understand?
All right, good luck, sir. Sir, please tell me your name.
My name is Juleno Nicholas.
All right, sir, you're here in 21 CF 9139, charged with aggravated battery. I'm going to appoint an attorney to represent you in this case. There is probable cause. Does this charge not qualify for pretrial release?
The charge qualifies, Your Honor, yes.
Do you know why he didn't? He doesn't have an extensive history.
He could qualify, Your Honor.
Ms. George? Did I appoint them? I'm appointing you to represent him. I also have a note about mental health.
Yes, Your Honor. Your Honor, I would ask for pretrial release. My client is on social security disability. He does not have a violent history. So I just ask that you take all of that into consideration.
What says the state?
Your Honor, if he otherwise qualifies for PTR, state has no objection. The only concern is, I believe they potentially live in the same home.
Yeah, I see that. All right. I'm going to have him screened for mental health pretrial release. If he doesn't qualify, pretrial release.
Thank you.
With special conditions, sir, you can't have any contact with the victim. Do you understand what no contact means?
Yes.
You also can't live in the same room. I'm going to order that you have to maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. So make sure that you talk to your attorney, and then if you get accepted into mental health pretrial release, they might also have some resources for you. But you can't live in that same room anymore, you understand?
Yes.
You can't possess a weapon of any kind, firearm, or ammunition. Good luck, sir.
Thank you.
Please tell me your name.
Peter Scortino.
21 CF 9167, you're here charged with 2 counts of lewd or lascivious molestation on a victim under 12. I'm going to appoint an attorney to represent you. There is probable cause in this case. Does the state wish to be heard?
Yes, Your Honor, given that they're both life offenses, state's asking that you hold them no bond pending an Arthur hearing.
Mr. George?
We reserve the right to have an Arthur hearing, Your Honor. No argument.
All right, I will do that at this time. You'll have no bond currently. But even while in custody, you can't have contact with any victim or witness in this case or the victim's family members. Do you understand that? All right, good luck. Wait, I also show that he's on sex offender probation?
Yes, Your Honor.
All right. You're not?
He's not on probation.
Okay. Oh, no, he's a registered sex offender.
Yes, Your
Sorry.
Honor.
So if you are a registered sex offender or predator, you have to maintain those reporting requirements. You understand that? You have to answer out loud. All right, good luck, sir. Good afternoon, counselor. Go ahead and put your appearance on record and call your case.
James Fierstein. I'm here on behalf of Mr. Miguel Strickland. I don't have a case number. I've just was appointed and.
I've got it. It's 21 CF 5910. Mr. Strickland, a warrant was issued for your arrest, charging you with 2 counts of lewd or lascivious molestation and 2 counts of lewd or lascivious conduct. So another judge has already found probable cause in this case. Counselor, did you wish to be heard on anything?
Yes, Your Honor. Judge, Mr. Strickland has no prior criminal history. The child has previously made other reports of abuse against both the mother and the father that have been determined to be unfounded. The mother, basically, the child is no longer living in the mother's house. She was asked to have her biological father come get her. They wouldn't do that, so she's with other family members now in Detroit, Michigan. So the child's not in the house. Again, he has no prior criminal history. He is a long-distance truck driver, judge, but he's again, never been charged with anything, so he's never had a failure to appear. Again, these allegations were made for the first time this year. Again, the wife requested, I'm not saying what the result is, the wife requested for her own peace of mind if he would take a polygraph, and he voluntarily took a polygraph. And he was never asked any questions by the police. He was never given an opportunity to cooperate or give his side of the story. He has lived in Florida for at least the last 4 years, and before that, he's been with the mother for over 7 years.
All right, are you asking for a specific bond?
Judge, I could ask for $3,000 per count.
All right, what says the state?
First, the state would contend that $3,000 per count is extremely low, given the nature of the offenses and the level of offenses. He's currently facing 2 F2s and 2 F3s. So while he is entitled to bond, state contends that $3,000 per count is extremely low, given that they are sexual in nature and the level of offenses. And then briefly as to counsel's argument, the victim's credibility is not at issue today. The victim's also not here to defend herself about what allegations were made and what were not. The child also left due to the officers, the CPT team, and everyone that was involved in this case believing that the mother would allow him back into the home and not believing her daughter. There is some slight history, I believe it's both driving history out of Ohio and Georgia. So he does have slight history, however, nothing as significant as what he's facing today. And in regards to the polygraph, as it's stated in the affidavit, it's unfounded, it's not reliable. They weren't able to determine the examiner or the company that this was done at. So it's not a registered or licensed place wherever Mr. Strickland apparently went to. So the state would just ask for a much higher bond than $3,000 per count.
All right, thank you both. Anything further?
No, Your Honor.
All right, at this time, Mr. Strickland, your bond is $25,000 on counts 1 and 2 each, and $5,000 on counts 3 and 4 each. With special conditions, you can have no contact with the child or the child's immediate family members. Do you understand that? That includes her mother. You can't have any contact with the mother. Do you understand? You can't possess a weapon, firearm, or ammunition. You can't have any contact with any minor child under the age of 18. Where's the child living?
She's currently living with a maternal aunt in Detroit, Michigan.
All right, you can't be within 1,000 feet of her residence or her school, which it doesn't sound like that would be an issue. Where's the mother living?
Orlando, Conway area.
All right, you can't return there. I'm ordering you to maintain a separate residence from the mother as well. I'll allow one-time return with law enforcement to gather your belongings. Any other conditions the state would request?
No, Your Honor.
Good luck, sir. Thank you, counselor. From the witness. Okay. Yeah. He's not allowed to be within 1,000 feet of the child's residence, but he can't live with the mother. Okay. That's the maintain separate. Please tell me your name.
Travis Anton White.
Sir, you're here because a capias was issued for your arrest in 2019 CF 13622 for failing to appear for a status hearing on a charge of possession of cocaine. There's no bond authorized at this time, and I'll appoint an attorney to represent you. Good luck, sir. Just one moment, counselor.
Yes, Your Honor.
Thank you. All right, counselor, if you want to put your appearance on record.
Benjamin Jones on behalf of Mark Proctor, Your Honor, case number 21MM5358.
And this is Mr. Proctor?
Yes.
All right, sir, you're here charged with resisting an officer without violence. Counsel, did you wish to be heard?
Yes, Your Honor, I'd like to challenge probable cause.
Go ahead.
Thank you. We need to begin by looking at the greater context of what officers claim led them to this area. They say that they received a generalized, nonspecific drug complaint, and then at some address that is not where Mr. Proctor was found, saw some individuals sitting. When they saw individuals sitting and then leaving, they then radioed to other people that apparently conveyed to law enforcement that individuals seemed to be existing and moving about public areas. When they then made a U-turn and approached Mr. Proctor with, according to their affidavit, not announcing their presence, not announcing why they were there or anything of that nature, they then decided that Mr. Proctor's apparent not walking to them constitutes resisting without violence. At the very least, I would say that because they say that this is all captured on body camera and that they are trying to say these very generalized, innocuous behaviors of human beings existing, that they then say that this gives them reason to detain someone, reason to say that their movement in a general direction constitutes flight. But this is all apparently captured on body-worn camera. If the court wants to make a probable cause finding, I would request that we at least wait until we see that body camera footage. The reason this is so important is, as the court is aware, Mr. Proctor is on bond for a trafficking charge. And I would rather get this right the first go-around than have to try to come back at some point in time and say that there actually is not probable cause as to this, and then we need to readdress what would seemingly be an inevitable revoking of his bond on the trafficking charge.
What says the state?
Your Honor, in regards to waiting till we have a body cams aren't ultimately available at this point, and a PC determination has to be made at IEA. And it won't be available for, I don't believe I'll be able to get it within the 48 hours if council is requesting a reset. So I don't believe waiting for a body-worn camera is a reasonable delay to wait for a PC determination. I believe PC can be determined off the four corners of the affidavit. It's been held that unprovoked flight from officers in an area of high narcotics supports reasonable suspicion that the defendant is involved in an activity and justifies a stop. The case I'm citing is Illinois v. Wardlow, which is the U.S. Supreme Court case from 2000. And I have a copy for both counsel and your honor, if you would like to see it.
Yes, please.
I may respond to the Wardlow argument, Your Honor.
I'm sorry, what?
I may respond to the Wardlow argument, Your Honor.
Yes, let me, if she's done with that argument. Are you done? Okay. Yes, go ahead, counselor.
The prosecution is correct that flight at the mere presence of the site of law enforcement in a high crime area can constitute a reasonable basis to command someone to stop. They didn't command anyone, according to this, but more importantly, though, if we're bound to the four corners of this affidavit, there needs to be something other than a blanket assertion that this constitutes a high crime area. If the officers want to base that for the purpose of probable cause, they need to include statistics or at least the reasons that they claim it is a high crime area. It is just a blanket assertion in here, and there's nothing to support that factually. So if we want to look at this based on the four corners of the affidavit as the prosecution asserts, there's nothing to support that this is a high crime area. So again, even if we are to say that headlong flight at the site of law enforcement constitutes a basis for a stop, that those facts aren't established within this affidavit.
All right, I'm going to need to just take a moment.
Yes, Judge.
All right, I have a question right away. I just started reading the opinion, Illinois v. Wardlow, 120 Supreme Court 673. The very beginning of the opinion, the recitation of the facts, it says, Respondent Wardlow fled upon seeing police officers patrolling an area known for heavy narcotics trafficking. Two of the officers caught up with him, stopped him, conducted a proactive, it says protective pat-down search for weapons, and then they arrested him. We hold that the officer stopped did not violate the Fourth Amendment to the United States Constitution. The very next paragraph. No, 2 paragraphs down. As the caravan passed, they observed Wardlow standing next to the building, holding an opaque bag. He looked in the direction of the officers and fled. Nolan and Harvey turned their car southbound, watched him as he ran through the gangway in an alley, and eventually cornered him. Nolan then exited his car and stopped the respondent. He immediately conducted a protective pat-down search for weapons, and that's when he found it. But this also doesn't say anything about officers announcing, saying, we're the police, you have to stop. That's not here. But I thought your argument was it needed to be there.
Well, my argument is that there's nothing within the four corners of this affidavit to establish that this is a high crime area. Therefore, law enforcement, if they want to rely on resisting an officer without violence, need to announce a command. If this affidavit did in fact establish that this is a high crime area, like was established at hearings in Illinois v. Wardlow, then they could rely on that. However, as long as we're looking at this affidavit, they are saying that at an area which is apparently a store across the street from where Mr. Proctor was found, they have received complaints of drug activity, and they cite a singular case. They cite OPD case number 21-00104137. I don't know if A, the area that they're referring to as high crime relates to this area where they saw people sitting on an ice cooler, or if that relates to where Mr. Proctor was found, which is not that. Even if it is considered to be the same area, I don't know that a singular cited complaint constitutes high crime.
Do you have
Right.
any?
Hold on, before we get any further, can I just,
Yes, Your Honor.
you said that the high crime area in Wardlow was established after many hearings,
Not many hearings, at a hearing.
or at a hearing. But we're here today for probable cause.
Correct.
Not beyond all reasonable doubt, not whether the state can sustain a conviction,
Correct.
but cause to believe that your client probably resisted without violence. That's the standard for today, right?
And we have an affidavit that cites a singular prior complaint. And if a singular prior complaint constitutes high crime, then literally the entire United States of America is a high crime area.
It says it should be noted the area is a well-documented and known to local law enforcement as a high crime and high drug area to which Ocala Police Department has received multiple drug activity complaints dating back to March. So it cites one case number, but it says it's a well-documented and known to law enforcement as a high crime area, and they received multiple complaints.
You're right, it is conflicting information. On the one hand, their narrative says one thing, but they support it with facts that don't establish what they.
Counselor, you're assuming facts, not an evidence here. One case number could contain multiple complaints,
Yes,
right?
Your Honor, it could.
I'm not assuming any facts here. I just want to look at what's here. Go ahead, Ms. May.
Just in regards to the saying that area's high crime, I believe it's sufficient from the four corners of the affidavit that it would satisfy probable cause. And in this particular case, we had the flight looking around the dumpster, observing that it's a marked cop car, and other people within the apartment building yelling, "The police are coming, the police are coming," or something to that effect.
Is there anything in this case, Counselor, that supports your argument that there needs to be something more specific to qualify it as a high crime area? Because I'm scanning for that, and I just want to know if I'm going to find it or if I should stop looking for
In
that.
Wardlow, there's not going to be that criteria. I do have that criteria. I wasn't prepared to bring that with you, Judge. I can submit a memorandum to Your Honor if you like. I've recently done research on this regarding the area around Rio Grande and Silver Star. And it's already written. I can submit it to you via an email if you like. But I wasn't prepared to present that case law today.
Your Honor, again, this is a probable cause determination, not a higher burden. And the case law that counsel most likely has isn't regarding a probable cause determination. It's most likely due to a trial determination, which would not be the standard that we're before the court for today.
The prosecution's correct, Your Honor. This is a lower standard. I would request, though, if the court has doubts as to the viability of establishing whether the area that Mr. Proctor was found in is the same high crime area that is alleged as this store where there are people sitting on an ice chest, to simply set bond in this case as where it stands at $500 and to delay taking action or take no action as to the trafficking case, which hasn't been charged. It's been sitting there since May, and it's still no information has been filed.
Is that correct, Ms. May?
1 second, Your Honor. That is correct. We're still waiting on FDLE to come back on the drugs.
It's an interesting argument, Counselor. I'm still leaning toward there's probable cause. Again, that's very different than whether the state can sustain this moving forward or whether they'll even file it. I have no insight into that at all. Give me a minute. I'm going to reread the entire probable cause affidavit to make sure that I recall everything correctly. Your client is 18,
Yes, ma'am.
so all of his prior history is juvenile?
Yes, Your Honor, I believe so. Yes, Your Honor. Which consists of violent history as well as other drug history.
Counselor, I do find probable cause exists here in this affidavit. I will set the bond at, I'll leave it at $500 with special conditions. Mr. Proctor, you cannot go back to this shopping plaza where the dumpster is. You know where that is?
Your Honor, I believe it was an apartment complex behind the gas station.
Do you live in those apartments? Oh, okay, you can go back to the apartments. Don't go back to the gas station. You understand? You can't possess a weapon, firearm, or ammunition, or any controlled substance without a valid prescription. Or what says the state as to out on bond case?
Your Honor, given his history, I understand that's not filed on. However, it did come in end of May. We're still waiting on FDLE. But given his history, I mean, his most recent history was a trespass that closed June 1st. So he does have some adult history. But prior to that, I have history of other trespasses, broken advances, grand thefts, petty thefts, armed burglary with a dangerous weapon, Warburg structures, trespasses, resistings, violations of probation, robberies, assaults, possession of cocaine, more possession of cocaine, another possession of cocaine.
I don't believe that all of those cases have resulted in adjudications of delinquency, Your Honor. I believe that
The assault, the robbery,
the robbery, I believe, was either downgraded or dropped completely, and there was another violent charge they read off that didn't end up.
Carjacking with a firearm?
Your Honor.
That's correct.
The point of this history I was reciting is he is 18. However, he has a very significant, at least, history with law enforcement of arrest and or with the court system. Most of them were, he pled no contest, some were adjudicated delinquent, some were not. However, he has a history of drug use as well as violent history, so state would ask that you revoke. And when the officers went back to the dumpster, they found other drugs when he's out on a drug case.
And the dumpster is not where Mr. Proctor was ever seen. They saw people sitting there at this convenience store with the dumpster, and then they essentially rounded up anyone that was in the area and told them to sit down.
The affidavit reads, a search of the area where we observed Proctor prior to him taking flight was conducted. We found blank, and it was the drugs.
Do you have any idea when you'll get your FDLE report?
I do not, Your Honor. I could ask the ASA that's on that case, but FDLE works at their own speed.
I know that is true. You represent him in the trafficking case as well?
That's forthcoming, Your Honor.
I don't have a defense attorney on that case yet, Your Honor.
I'm sorry, what?
I don't believe there's a defense attorney on that case yet.
That's correct. I've essentially hired today, Your Honor.
I see. All right. He's going to file an appearance today. So don't, well, I'm not going to appoint the PD. Does your client have a job?
He works cutting grass for his sister, Your Honor. And I would just like to note, Your Honor, if it does seem that what the prosecution has in this case is that Mr. Proctor was near a place where drugs exist, and they are right, this is in fact a high crime area, he's always going to be in constructive possession of something. because he lives there. And it's just being near his home where there's a convenience store where apparently people keep drugs in a dumpster or in an icebox, he's always going to be accused of having something having to do with those if he does live in this apartment complex. He can't not be there.
Your Honor, that's purely speculative. I mean, there's constructive possession. He could exercise dominion and control. It was in the area where they saw him before he fled.
I understand what you're saying, Counselor, and Mr. Proctor, if I were you, even if you do live right behind that gas station, if I was out on bond for a trafficking charge, I don't think I would be anywhere near anybody else who's doing anything illegal, because you understand that every time you get arrested, your bond can be revoked, and you can be held at no bond. I just want to make sure you understand that. I'm not going to revoke it at this time, Counselor, but your office can file a motion to revoke it when you get your FDLE report. Thank your attorney. He did a great job for you today. Good luck, sir.
Thank you, Judge.
Thank you, Counselor. Oh, that's not what I want.
Good afternoon, Your Honor. This is Ali Figueroa, a certified Spanish County interpreter.
Please, has the interpreter been sworn?
Yes, Your Honor.
Please connect with the headset.
Connected.
Sir, please tell me your name.
Israel Garcia Vasquez.
Israel Garcia Vasquez.
21 MM 1872, a capias was issued for your arrest for failing to appear for a pretrial conference on a charge of petty theft. The bond is $2,000, and I'll appoint an attorney to represent you. In 21 MM 5359, you're here charged with trespass on property after warning. Is there an offer in this case?
Yes, Your Honor, there's an offer on both. On the trespass, it's an adjudication, credit time served, and no return to the Lynx bus station. And in the failure to appear petty theft case, the offer is an adjudication, credit time served, no return to the Walmart located at 11250 West Colonial.
Ms. George, did you have an opportunity to speak with him?
No, Your Honor, I had no one.
Mr. Garcia Vasquez, are you interested in accepting the state's offer today?
Sí.
Yes.
I need you to raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Hey, yes.
Thank you. All right, sir. You understand that if you enter a plea of guilty or no contest to these charges, you'll be waiving or giving up certain constitutional rights, including your right to remain silent, your right to testify on your own behalf, your right to a jury trial when one is required, and to call witnesses who would appear and testify in your defense. You're giving up your right to raise any defenses that you have in these charges. You also understand that if you're not a U.S. citizen, you can be deported if you enter a plea of guilty or no contest. Do you understand those rights, sir?
Yes.
Do you have any questions for me about those rights?
No, no bongo.
No. No contest.
Do we have a plea form in Spanish that we can give him? Sir, I want you to look at that form and review those rights, and then let me know when you're done.
Yes, in English.
Spanish.
Ms. George, can you give that same plea form, well, a new copy to each of the Spanish-speaking individuals so that they can review it
Yes, Your Honor.
while they're waiting? I don't know how many we have.
I don't think
That's
the other,
not pleading.
the other two aren't pleable, Your Honor.
Oh, never mind then.
You want that?
All right, sir, you've read the form. Do you have any questions for me about what's on that form?
No, entiendo.
No, I understand.
O no me pongo.
No contest.
All right. At this time, I'll accept your pleas of no, before I do that, I need to make sure that you understand that petty theft is what we call an enhanceable offense. What that means is, after so many convictions, the state can charge that crime as a felony, punishable by up to 5 years in prison. Do you understand that?
Entendido.
Understood.
All right. At this time, sir, I'll accept your pleas. I find they're freely and voluntarily made. I'll adjudicate you guilty on both charges, give you credit for the 2 days that you've been in custody. I have to order that you pay court costs. I'll give you a year to pay that. And you're not allowed to return to both of the addresses that the state already said, the Lynx bus station on Garland Avenue and the Walmart.
Yes, Your Honor, located at 11250 West Columbia.
All right, you understand you can't go back to those places, sir?
Yes.
All right, good luck, sir. You have 30 days to appeal in writing. Thank you. Sir, please tell me your name.
Cristian Malpica Sánchez. Cristian Malpica Sánchez.
Christian Malpica Sanchez.
21 CF 9140, you're here charged with felony battery. There is probable cause. I'll appoint an attorney to represent you. Your bond is $2,500.
Does qualify for pretrial release? He has no criminal history. Convictions, I would ask for.
Says the state.
Your Honor, given the enhanced nature of this charge and given that he's already been arrested for a battery before, if you are inclined to put him on pretrial release, they would ask for bond with pretrial release.
I'm going to place you on pretrial release and require that you post a $500 monetary bond with special conditions. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Sí. Yo tengo la licencia revocada y mis cosas, mis pertenencias están en casa de mi hermana y eso fue en casa de mi hermana, so tendría que ir a buscar mis pertenencias en la casa de mi hermana.
My license is revoked and all my belongings are at my sister's house. The incident took place at my sister's house. I will need to go back to get all of my belongings.
I was going to order that you must maintain a separate residence, but I'll allow a one-time return with law enforcement to gather your belongings. You also can't possess a weapon of any kind, firearm, or ammunition. Good luck, sir. Please tell me your name.
René Emilio Méndez Molina. René Emilio Méndez Molina.
Rene Emilio Mendez Molina.
21 CF 9125, you're here charged with sexual battery. There is probable cause. I'll appoint an attorney to represent you. Does the state wish to be heard on bond?
Yes, Your Honor. He is charged with an F2, so he is entitled to a bond. However, state's asking for a higher bond than usual, given one, the charge, two, the facts that are alleged in this affidavit, including the threats of prepare yourself because what happened the other night, what's going to happen tonight. Also he has no ties to the community other than the victim in this case. The victim alleged that he came to the U.S. illegally about 3 months ago. So he has very limited criminal ties to the community, as well as the facts and the threats in this case. They're asking for a high bond.
What says the defense?
Your Honor, I would argue that he has no criminal history here. And I would argue that it appears he's been here for 3 months to a year. He's been employed 6 months at a construction site. So just take that into consideration.
Your bond is $250,000. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Sí, ¿cuánto dijo?
Yes.
Disculpen.
How much did you say? I'm sorry.
$250,000. You can't return to this scene for any reason. You can't possess a weapon, firearm, or ammunition. You can't be within 1,000 feet of the victim's home or place of business. Do you understand?
Sí.
All right, good luck,
Yes.
sir.
He does have
I'm sorry, what?
Una pregunta.
immigration hold.
Oh, thank you. Yeah, actually, sir, you also have an immigration hold, so even if you post that bond at this time, you won't be released.
¿Y podré hacer una llamada?
Could I make a phone call?
Yes.
Yes. Mire, yo necesito sacar un número de mi familiar en mi teléfono que me tiene la policía, porque no tengo un número aquí para poder llamarle a mis hermanos y poder pagar esa mi fianza lo más pronto posible que pueda.
I would need to get the number from my cell phone, the one that the authorities took from me, because that's where the number is. I need to get the number so I can call my family.
Look at the piece of paper in front of you. It has a number that you can call to speak to your attorney. Talk to your attorney about how to do that.
Muy bien, gracias.
Okay, thank you.
Yes, sir. Good luck.
Gracias.
All right, that's all we have for Spanish this afternoon.
Thank you.
Thank you. (21 MM 4941). Ms. George, your office already represents him.
I'll waive and enter a plea of not guilty, Your Honor.
Division 83, pretrial conference, August 23rd at 8:30, courtroom 6C.
Hi,
Please tell me your name.
my name is Elizabeth Dolores Jimenez.
21 MM 4793. You're here charged with trespass on property other than a structure or conveyance. Ms. George.
I'm going to enter a plea of not guilty, Your Honor.
Division 81, pretrial conference, August 20th at 9 o'clock, courtroom 4E.
Good luck, ma'am.
Okay.
21 MM 4707. Your office already represents him. Ms. George.
I'll waive and enter a plea of not guilty.
Division 50, pretrial conference, September 8th at 1:30, courtroom 7C.
Sir, please tell me your name.
Mavronis Harry.
21 MM 4706. You're here charged with a trespass on property other than a structure or conveyance. You're represented by the Office of the Public Defender.
Okay, I just want to make sure. We'll enter a plea of not guilty, Your Honor.
Division 82, pretrial conference, August 30th at 10:30, courtroom 10B.
I'm just trying to resolve this.
I can't hear you, sir.
It's just a trespass charge. I'm just trying to resolve this. I got 20-something days in. I'm just trying to resolve this, you know what I mean?
The state's not required to make an offer, and they're not at this time. You're gonna have to call your attorney to find out what your next steps are.
Your Honor, it's a private residence and the victim has a temporary protection order against the defendant.
I understand. Call your attorney, sir. Please tell me your name.
Tyler Warwick.
21 MM 255. You're here charged with trespass on property other than a structure or conveyance and possession of drug paraphernalia. Ms. George, your office represents him.
Yes, Your Honor. The state's offered an adjudication of guilt, credit time served, and no return. I don't have the address, if you can pull it up for me. And cost of investigation of $174.25 to Apopka Police Department. As far as the drug paraphernalia, are you gonna announce okay, no information? And Your Honor, no pros. Your Honor, I did, speak to my client. We went over all the rights he would be giving up. He understands those rights and would like to resolve the case today.
Mr. Warwick, please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I do.
Thank you.
All right. You heard what Ms. George just said. Is that what you want to do here?
Yes, ma'am.
You understand all the rights you're giving up if you enter a plea of guilty or no contest?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
You understand if you're on probation anywhere, this plea can violate that.
Yes, ma'am.
If you're not a U.S. citizen, you can be deported.
Yes, ma'am.
At this time, how do you wish to plead to the charge of trespass on property other than a structure or conveyance?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 44 days that you've been in custody, order that you're not allowed to return to the scene. You'll have to pay $174.25 to the Apopka Police Department for the cost of investigation and court costs. Court costs are around $300. How long will it take you to pay all of that?
I'm not exactly sure. Hopefully within a timely manner.
I'll give you a year.
Thank you, Your Honor.
Thank
All
you.
right, good luck, sir. You have 30 days to appeal in writing.
Thank you.
Your Honor, for the record, the address is 700 South Orange Blossom Trail. It's a racetrack, and state announces a null process to count two.
All right, good luck. Please tell me your name.
Ryan Bancroft.
21 MM 5362. You're here charged with trespass. There is probable cause. Was there an offer?
Not this time, Your Honor.
Your Honor, I would just ask that it does not appear he was interviewed. I would ask that he be interviewed for pretrial release. He is homeless, and if you read the arrest affidavit, it stated that he was seeking shelter from the rain and to sleep. So I ask that.
I'm sorry, he was interviewed.
Okay, I don't have a.
He still didn't qualify.
Okay.
All right, I'll stay the bond at $250, sir. You're not allowed to return to 1207 West Central Boulevard. You understand that? You have to answer out loud.
Yes, ma'am.
All right, good luck. Please tell me your name.
Clifford Brown.
All right, Mr. Brown, you're here charged with resisting an officer without violence in 21 MM 495. Let me ask the state if there was an offer.
Not at this time, Your Honor.
Your Honor, I would ask for pretrial, he be screened for pretrial release. He has no criminal history. He has been Baker acted 3 times within the last couple of years, so I just ask that you take that all into consideration and release him on pretrial release.
Can we have him screened for mental health pretrial release, and then if he doesn't qualify, we'll put him on pretrial release?
Thank you, Your Honor.
Sir, you can't go back to Oxum Coffee right now. Do you understand that?
Yes, ma'am.
All right, good luck, sir.
Am I free?
No, you're going.
Question, please. I know I'm not trying to press anything, but there's a place called Universal Healthcare Facility. I want to get a competency test. Universal Healthcare Facility is like I was Baker after they sent me there, but I want to volunteer. I think like a day or two, or maybe 3 days, to get a competency test.
All right, so what I've ordered is, you won't be released right now because I've ordered that you'll be screened for a program that we call mental health pretrial release, which means you would be released without having to post a monetary bond, but we have to screen you to see if you qualify. And part of that would be some mental health services, but your attorney right there is gonna make a note in her file to have you evaluated.
Absolutely. Thank you very much.
Yes, sir, good luck.
Could I ask you, how long,
Yes.
how many more days I have to wait?
I don't know. Sometimes mental health pretrial release takes a couple of days, so it might be at 3 or 4 days before you get out.
All right, thanks for being honest. I appreciate it. God bless you.
Yes, sir. You too. You did put that, right?
Yes, Your Honor, I have it once.
I assume that you did, but.
Yes, Your Honor.
All right, 21MM 339, trespass. I'm going to appoint your office, Ms. George.
Oh, okay, found it. Yes, Your Honor, I'll waive, you said he's, I'm sorry.
Medical.
Do you think he'll come tomorrow? Can we try to reset him for tomorrow, Your Honor? Because there was an offer to resolve the case. I don't know what he was medical for.
And also the failure to appear on indecent conduct.
There's an offer for that as well.
There's an offer for that as well, Your Honor, that's why I wanted to reset.
All right, we can reset him.
Thank you.
Yeah, but they're not going to do it. But yes, put PM like it's supposed to be. Please tell me your name.
Tara Ebenezer Dickerson.
21MM 5357. Ma'am, you're here charged with trespass on property after warning. Was there an offer in this case?
Yes, the offer was an adjudication, credit time served, and no return to the 7-Eleven.
Your Honor, Ms. Dickerson would like to accept the state's offer here today.
You did explain to her that she's out on bond?
No, I'm not. No, I'm not. I'm not.
No, I did not, Your Honor.
And that can still be revoked?
Absolutely.
Yes.
Your Honor, for the court's, just candor to the court, that case is 5 charges. Petty theft 2 prior, resisting a merchant battery, possession of meth, and resisting without. She picked that up June 13th, and we have not filed an information on it yet.
Thank you.
Ms. Dickerson understands that. However, I would just ask that since no information has been filed, she was released on a 33-day motion, that you take no action since she is going to resolve this case today.
All right, Ms. Dickerson, raise your right hand, please.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
All right, you heard what Ms. George said. Is that what you want to do here today?
Yes, ma'am.
And you had a chance to discuss with her all the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
You understand if you're on probation anywhere, this plea can violate that.
Yes, ma'am.
And if you're not a U.S. citizen, you can be deported.
Yes, ma'am.
All right, ma'am. At this time, how do you wish to plead to the charge of trespass on property after warning?
Guilty, please, ma'am.
I can't hear you.
Guilty, ma'am.
All right, I accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days that you've been in custody. I'll order that you're not allowed to return to the 7-Eleven at 938 West Colonial Drive. You understand that?
Yes, ma'am.
You can't go back there. All right, I have to order that you pay court costs. I'll give you a year to pay them. At this time, I'm going to take no action on your out on bond case. Good luck, ma'am. You have 30 days to appeal in writing.
Thank you. Have a good day.
You too. Please tell me your name.
BOBBYLEEGREEN.
All right, thank you, Mr. Green. You're here in 21MM 5360, charged with trespass. Was there an offer in this case?
Yes, Your Honor, the offer conveyed was an adjudication, credit time served, and no return to the In-N-Out gas station at 2012 South Orange Blossom Trail.
And Your Honor, he's been deemed permanently incompetent to proceed, dating all the way back to 2010. I would just ask that you take that into consideration, and even in looking at the facts, he was screaming at customers. He is a military vet. I know he's high in the risk assessment, but I would ask for pretrial release in this case. I know you could still place him on pretrial release.
Not with mental health issues.
Mental health pretrial, no?
Well, screen for mental health, but not PTR.
Yeah, screen for mental health pretrial release. He has multiple cases. He's been deemed permanently incompetent, Your Honor.
Mr. Green, you were in the Army?
Yes, ma'am.
Do you remember where you were stationed?
Yes, I do remember.
Can you tell me at least one place you were stationed?
Fort Dix, New Jersey, and Fort Belvoir, Virginia.
All right, well, thank you for your service to our country.
Quite welcome, ma'am.
Mr. Ward, based on all the things you've said and the facts in the affidavit, I'm inclined to have him screened for mental health pretrial release, but I understand that could take days.
Yes, Your Honor. I would like to ask for ROR in this case. It's a unique situation, Your Honor. He was screaming at customers, but it seems that, like I said, dating all the way back, he's been deemed permanently incompetent. And at this time, even after I tried to speak with him back there, it's clear that he does not fully grasp what's going on here today.
But do you think it'd be better for him to be placed on mental health pretrial release or not?
No, Your Honor.
All right. Does the state object?
To ROR, yes, Your Honor, he has 4 failures to appear, one as recent as 2 years ago. And then other than that, he has a fairly lengthy history. And given that he is incompetent, per counsel, I'm unsure if he could maintain keeping up with this case, given his prior history and his failures to appear.
Are you going to give him a piece of paper with your phone number?
Yes, Your Honor.
All right, Mr. Green.
Pardon?
If I release you on your own recognizance today, will you stay in touch with your attorney?
Of course I will, sir.
And will you come to court when the judge says you have to?
Yes, ma'am.
All right, I'm going to release you on your own recognizance, but I'm ordering you, Mr. Green, that you have to stay in touch with your attorney. Do you understand that?
Yes, ma'am.
And you cannot go back to the In-N-Out gas station at 2012 South Orange Blossom Trail. So you understand you can't go back to that gas station?
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
Michelle Siegel, Cologne.
A capias was issued for your arrest in 20 MM 6014 for failing to appear for a pretrial conference on a charge of petty theft. The bond is $1,000. I'm appointing an attorney to represent you.
Your Honor, there was an offer of a withhold credit time served and no return to 3838 North Cimarron, and a cost of investigation of $48.52 to Orlando Police Department. I did have a chance to speak with my client. We went over all the rights she would be giving up. We also went over the fact that she could possibly get referred to pretrial diversion. However, she feels it's best to resolve her case today and enter a plea of no contest.
Why would I withhold adjudication?
She has no history. No
She does.
convictions, Your Honor.
I'm sorry?
She has no criminal convictions that I see on her record, Your Honor.
There's a leaving the scene of an accident from 2018. That was a withhold. The reason for the state's offer of a withhold was due to the enhanceable nature of the offense. It's her only petty theft or any theft of any kind. Everything else is either drug-related or driving-related. I believe she's currently in PTD now for a drug case.
Your Honor, and in this case, given that she is going to resolve, I just would like to give you some background knowledge. She was actually seeking treatment at the time that the failure to appear was issued. She was in drug treatment facility when the failure to appear was issued. She was on lockdown because of COVID. So I just would like to bring that to your attention.
All right, thank you, Counselor. Ma'am, raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you.
All right, you heard what Ms. George said. Is that what you want to do here today?
Yes.
You had a chance to discuss with her all the rights you'll be giving up if you enter a plea of guilty or no contest. Do you understand those rights? Do you have any questions for me about those rights?
No.
You understand that petty theft is an enhanceable offense, which means after a certain number of convictions, the state can file it as a felony, punishable by up to 5 years in prison.
Understand that.
All right, you understand if you're not a U.S. citizen, you can be deported?
Yes.
And if you're on probation anywhere, this plea can violate that.
Yes.
At this time, how do you wish to plead to the charge of petty theft?
Contest.
I'll accept your plea. I find it's freely and voluntarily made. Based on your attorney's representations, ma'am, I will withhold adjudication. I'll give you credit for the time that you've been in custody. I have to order that you pay court costs and the cost of investigation of $48.52. I'm going to give you a year to pay that. Where's the no return?
Walmart, located at 3838 North Cimarron.
You can't go back there. Do you understand?
Yeah, the last time I went to court about that, they told me I couldn't be there for a year, and I already paid my court fees and everything for that when I went to court the first time.
But now I'm ordering that again.
Okay.
So just find a different store. All right, good luck, ma'am. You have 30 days to appeal in writing.
Pretrial, you said 4?
What's the cost of investigation?
4852 to OPD.
OPD. Please tell me your name.
Miscellaneous Simmons.
21MO887. You're here charged with disorderly conduct. Was there an offer?
Yes, Your Honor, I've been authorized on the city's behalf to offer a withhold credit time served.
And Your Honor, I did speak to Ms. Simmons. We went over all the rights she would be giving up. She understands those rights and would like to accept the state's offer here today.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
All right, you heard what Ms. George just said. Is that what you want to do here today?
Yes, ma'am.
You understand all the rights that you're giving up if you enter a plea of guilty or no contest?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
You understand if you're on probation anywhere, this plea can violate that.
Yes, ma'am.
If you're not a U.S. citizen, you can be deported.
Yes, ma'am.
At this time, how do you wish to plead to the charge of disorderly conduct?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in custody. I have to order that you pay court costs. I'll give you a year to pay them. All right, good luck. You have 30 days to appeal in writing. What about Perry? James? All right, Blanding, 21 CF 9157. I will find her refusal a willing waiver of her appearance today. There is probable cause. I'll appoint the public defender's office. The bond is $1,000 on count 1, 100 on 2 and 3. No contact with any known drug dealers. Not return to this location. Can't possess or consume any controlled substance. And that's it. Please tell me your name. A warrant was issued for your arrest in 21 CF 9164, charging you with aggravated assault with a firearm. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you.
Establishment of probable cause, ma'am?
I'm sorry, what?
Establishment? The proof of probable cause?
No, I don't have to prove the probable cause. No. So a warrant was issued for your arrest, meaning another judge has already reviewed the affidavit for probable cause and found that there was probable cause. So that finding's already been made. Does the state wish to be heard on bond?
Your Honor, the state's only thing I would like to point out is I believe it was at the victim's residence. And in the defendant's history, there is another prior firearm charge. I just asked for a bond in conjunction.
Ms. George, did you wish to be heard?
I would just Ask that you consider the fact that the last conviction that I'm showing, Your Honor, was from 2017 when setting the bond amount.
All right, ma'am, your bond is $10,000. You can have no contact with the victim. Do you understand what no contact means?
Now that's why my bond is $10,000.
Yes, based on the facts of this case, your history, and the inability to verify any community ties. That's why I placed your bond at $10,000. I'm ordering you can have no contact with the victim. Do you understand what no contact means? Ma'am, do you understand what no contact means?
Yeah.
You cannot possess a weapon of any kind, firearm, or ammunition. You cannot be within 1,000 feet of the victim's place of residence or place of employment. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, ma'am.
What do I have to verify to get my bond lowered?
At this point, your attorney will have to file a motion to reduce your bond in front of the trial judge. Please tell me your name.
Charles Hamer.
Sir, you're here in 21 CF 9145, charged with aggravated assault with a firearm. There is probable cause. I'm going to appoint an attorney to represent you.
Your Honor, I would ask for pretrial release. He does qualify, and it appears, one, he is a military veteran. Two, he's been in the Orlando area for over a year. He has no criminal history. So I ask that you take all of that into consideration.
What says the state?
Your Honor, state would ask for bond in conjunction with PCR, given that it is a firearm offense, and given that the dispatch tried to discourage the situation, however, it was escalated due to following the victims throughout the community.
All right, sir, I'm going to place you on pretrial release and require that you post a monetary bond. However, I'll reduce that amount significantly. You'll have to post a bond of $1,000. While on pretrial release, you can have no contact with the victim or any witness in this case. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. Where did this take place, Ms. May?
It was at the apartment complex.
But it's where he lives, right?
The juveniles were visiting, I believe it was 4 juveniles, they were visiting one of their aunts.
Yeah, okay, all right. That's it. Good luck, sir.
Okay.
21 CF 9155. Ms. George, I'm going to appoint your office.
I'll waive the appearance, Your Honor.
All right. There is probable cause. I'm going to stay the bonds at 100 and 1,000. No victim contact, no witness contact, no weapons, firearms, or ammunition. Please tell me your name. A capias was issued for your arrest in 18 CF 3595 for failing to appear for a status hearing on charges of possession of heroin and drug paraphernalia. There's no bond authorized on that capias, and I'll appoint an attorney to represent you, sir. Good luck. Please tell me your name.
Oh, Liberty Johnson.
A capias was issued for your arrest in 20 CF 12595 for failing to appear for a plea hearing on a charge of aggravated battery with a deadly weapon. There's no bond authorized on that capias, and I'll appoint an attorney to represent you. Good luck, ma'am.
No rush.
Please tell me your name.
Lincoln King.
A warrant was issued for your arrest in 21 CF 7346, charging you with burglary of an occupied dwelling and criminal mischief. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you.
Ma'am,
Does it? Yes, sir.
sorry. I live there. This is my address, ma'am.
All right, so I think that what you need to do is talk to your attorney if you think you have some defenses to this, because they're going to have to file a motion in front of the trial judge. Hold on one moment.
Your Honor, it's alleged that he broke the windows of the bedroom, then kicked in the front door. And later in the warrant, it states that he was gone for approximately 2 months and relinquished residency and no longer had any personal property there. Arguably, this case is actually a burg with a battery therein of the new boyfriend. So state would ask for a bond higher than normal, given the facts alleged.
Your Honor, I would just argue that he was charged with the burglary of an occupied dwelling. I ask that you set bond in accordance with that, and he also has 0 failures to appear. His last conviction was in 2008, and it does not appear he has a relatively violent history. So I just ask you to take all of that into consideration.
I'm going to set your bond at $10,000 on count 1 and $1,000 on count 2. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't return to this scene for any reason. All right, good luck, sir.
Ma'am, I've been living there since this happened.
So in the affidavit, I just reread it when you were talking about that, and it says that you did live there at one point, but you don't now, and you're not supposed to be there. So I think, listen, I think you have some defenses, but you can't raise them today. You need to talk to your attorney, and then they need to raise them with the state before they file charges, and then if they do file the charges, they'll have to raise it in front of the trial judge.
So is there no way I can get my bond lower than 10,000?
Not today. I actually did lower it, sir, from what I was going to put it, based on your attorney's arguments. Good luck, sir.
Last refuse.
21 CF 9151. I find his refusal a willing waiver of his appearance today in court. There is probable cause. I'll appoint an attorney to represent him. I'll stay the bond at $100,000 on count 1, 15 on 2 and 3, and $1,000 on count 4. No contact with any co-defendant or witness in this case. No weapons, firearms, or ammunition. No contact with any drug dealers. Not allowed to possess or consume any controlled substance without a valid prescription. That's it. Please tell me your name. In 21 CT 5485, you're here charged with driving while license suspended or revoked. There is probable cause for this charge. I'll appoint an attorney to represent you. Your bond is $500. You understand you can't drive without a valid Florida driver's license?
Yes, ma'am.
All right, and then in 21 CF 9156, you're here charged with possession of cocaine and drug paraphernalia. There's also probable cause here. I'm going to appoint an attorney to represent you.
Your Honor, he does qualify for pretrial release. I would just ask for pretrial release in this case.
What says the state?
Your Honor, state would object. He has a very lengthy criminal history,
Yeah, I'm surprised that qualifies.
Don't talk about the facts of the case.
including other dwellers HTOs, including other paraphernalia, other drugs. So state would object, Your Honor. One being delivery of cocaine and F1.
I'll just say something, Your Honor.
So you can say anything you want, but I want to make sure that you understand everything you say today is being recorded and can be used against you later. Do you understand that?
Yes, ma'am.
All right, yes, sir, go ahead.
I'm just down here to work. I've been out here since January working, and my boss man, his tag was bad and I got pulled over and they found something in the car.
I see. It sounds like you think you have some defenses. You need to call your attorney to raise those with your attorney. Because this is just the probable cause hearing. But I'm going to place him on pretrial release.
Thank you.
However, sir, you're going to be subject to random drug screens while you're on pretrial release. You can't possess or consume any controlled substance without a valid prescription. And again, you can't drive without a valid Florida license. You also can't have contact with any known drug dealers. Do you understand?
Yes, ma'am. I don't know anybody down there.
Good, then that one will be easy. Thank you, sir. Good luck. Just for the felony. I'm sorry?
It's still 500 on the Dwellis?
Yes. One moment. Sir, please tell me your name.
Right. Tobias McElroy.
21 CF 9146. You're here charged with tampering with physical evidence, possession of cannabis under 20 grams, and possession of drug paraphernalia. I'm going to appoint an attorney to represent you. Did you wish to be heard, Ms. George?
Your Honor, I would argue no PC for the tampering with physical evidence. Based on the arrest affidavit, it stated they found the drugs in his pants.
Your Honor, state has no argument. I agree with defense. The officer was observing the defendant. He entered the vehicle. As he got into the driver's seat, he placed the unknown object in his waistband area. He did not know the officer was surveilling him or observing what he was doing at the time. There was no investigation. I don't believe there's PC as to the tampering.
I had the exact same question, so I agree with you both. I'm going to release you on your own recognizance on count 1, the tampering charge. I don't find probable cause for that. However, there is probable cause for the other 2. So your bond will be $500 on count 2, $100 on count 3. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
What about that? I would have got out last night, but I got a,
I'm getting there. I'm going to take no action on his out-of-bond case. Good luck, sir.
thank you.
Please tell me your name.
Isaac McGlamory.
A capias was issued for your arrest in 21 CF 4862 for failing to appear for a status hearing on a charge of possession of fentanyl. There is no bond authorized, and I'll appoint an attorney to represent you. Good luck, sir.
Is that it?
That's it.
Okay. Here you go.
Please tell me your name.
Mercado.
What's your whole name?
My full name, Herberto.
All right, sir, you're here in 2019 CF 15550. A capias was issued for your arrest for failing to appear for a hearing on charges of false imprisonment and battery. There's no bond authorized on that capias, and I'll appoint an attorney to represent you. Good luck, sir. Please tell me your name.
Edwin Perez.
A warrant was issued for your arrest in 20 CF 9302, charging you with burglary of a dwelling, grand theft, and criminal mischief. Another judge has already found probable cause.
Your Honor, and information has also been filed with those same charges.
And information has already been filed. I'm going to appoint an attorney to represent you. Your bond is $10,000 on count 1, $2,500 on count 2, and $500 on count 3. You're not allowed to have contact with any victim or witness in this case or return to the scene. Do you understand? All right, good luck, sir.
First, please, in the hospital.
21 CF 9158, Ms. George, I'm going to appoint your office.
I'll waive the appearance, Your Honor.
There is probable cause in this case? Yes. Ms. May, did you wish to be heard?
Yes, Your Honor, as to count 2, the attempted felony murder, given that it is a life offense, state is asking that you hold her no bond pending an Arthur hearing.
I will do that. I'm going to raise the bond on count 1 to $15,000, no bond on count 2, no contact with any witness even while in custody. And at this time, I'm revoking her bond in 21 CF 5943. Oh, we have an attorney on this one. They're there.
Welcome to an Econo meeting. You are entering the meeting now.
5943. Good afternoon, counselor. Can you hear me? Oh, we have an attorney on this one. Hi, this is Judge Gibson. Can you hear me?
Your Honor, can you hear me?
Yes, we can.
Okay, excellent. This is Attorney Dion Talkington Fletcher. I believe that I will be retained later this evening on, that looks like Ms. Prince.
Ma'am, please tell me your name.
Monique Prince.
All right, so you don't actually represent her at this time?
I believe that I will be this evening, so I wanted to appear on the AIA. I do not show any documents as far as an arrest affidavit online yet. I realize this is quite a recent arrest.
Yes, she actually has 2 cases. 21 CF 9144, you're here charged with possession of a controlled substance and possession of cannabis less than 20 grams. There is probable cause in that case. I'm going to stay your bond at $1,000 on count 1 and $100 on count 2. With special conditions, you can't have any contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. Do you understand? And then in 21 CF 9168, you're charged with trafficking in fentanyl, 4 grams or more, conspiracy to sell or deliver cocaine, conspiracy to possess a controlled substance with intent to sell, possession of methamphetamine with intent to sell, possessing a place or structure known to sell drugs, unlawful use of a two-way communication device, conspiracy to traffic in a controlled substance, and that's it. So, counselor, you don't wish to be heard on probable cause on this charge? You haven't reviewed the affidavit?
I've not been able to read anything online as to the affidavit. So while I'd like to preserve my right to challenge probable cause, I have nothing to base it on at this moment. I can tell you that as far as bond and release conditions, the only criminal history Ms. Price has is a no valid DL adjudication withhold in 2015. And I believe there may have been like a minor school skirmish in 2009 as a minor. That's it.
Right.
Her entire family is here in Central Florida, and she is the sole physical custodian for her niece. The court granted that custody in 2018.
All right, thank you. I reviewed this affidavit. I already found probable cause for the co-defendant, and I do believe there's probable cause for these charges in this case as well. I'm going to stay the bond at $100,000 on count 1, $15,000 on 2, 3, 4, and 5. I'll reduce count 6 to $150. And count 7, it's $100,000. You can't have any contact with any known drug dealers, any co-defendant in this case. You can't possess or consume any controlled substance without a valid prescription. Can the state tell me what is the name of this motel? I can't find it now quickly in the affidavit. Sunstyle Suites, 7209 South Orange Blossom Trail. You can't go back there. Do you understand that? All right, good luck, ma'am. Thank you, counselor, for appearing.
All right, thank you, Your Honor.
Sir, please tell me your name.
Subati Sayer.
21 CF 9152. You're here charged with trespass on a designated construction site. I'm going to appoint an attorney to represent you. Ms. George, did you wish to be heard?
Not on probable cause, Your Honor.
All right, there is probable cause in this case. Did you wish to be heard on bond?
Yes, Your Honor. I'm not sure why he doesn't qualify for pretrial release. He has no criminal history other than a battery arrest. He was sleeping there. It appears my client is homeless, so I would ask for an ROR in this case. He's never been convicted of any crimes.
What says the state?
The state has no objection, Your Honor. Would just ask for a no return to the area.
It's a felony.
I think it's because it was in the construction site, Your Honor.
It is.
Yeah, the reason the state has no objection, Your Honor, is it doesn't seem that there was any damage to the property. And I believe he just had a caliber of ammunition on him and some clothing. So his story of sleeping there does seem accurate.
All right, sir, at this time, I'm going to release you on your own recognizance, but I'm going to order that you can't go back to this location. Do you understand that?
Yes, ma'am, that is understood.
All right, good luck, sir. Stay in touch with your attorney.
Tadiba Tsunami. Bonding, Your Honor.
Okay. Please tell me your name.
Unique Tanis. I have an attorney. Is he not here?
Who's your attorney?
Kwasi Corey.
I'm sorry, say that one more time.
Kwasi.
I don't have any notes about that. Does the clerk, can you see if you have a notice of appearance in this case? This is 21 CF 8323. Let me go online and see if anyone else is on the video conference.
Welcome to an Econo meeting.
There notice?
You are entering the meeting now. You are the only participant.
Your Honor, I don't see a notice on the clerk's side.
Okay.
And there's nothing in the notes saying they contacted the state attorney's office or anything.
All right, ma'am. A warrant was issued for your arrest, charging you with burglary of a dwelling with a battery. I know you said you think you have an attorney, but your attorney hasn't filed an appearance yet in this case. So I can appoint an attorney to represent you, at least right now, until your attorney files something, or not. Tell me what you want me to do.
You can appoint me an attorney, please.
Yes, I will appoint an attorney to represent you at this time. There is probable cause. I signed the warrant. Does the state wish to be heard?
Yes, Your Honor, given that it is a PBL, state's asking that your order no bond pending an Arthur hearing. I understand that we had a hearing regarding misvigilance last week, I believe. However, I believe your finding of giving her a bond was also due to her certain circumstances, one of them being moving from the state. So state would ask that you hold her no bond pending an Arthur hearing to when her attorney that she believes that she retained can appear and potentially get her a bond.
Ms. George?
Your Honor, I would just ask that you consider setting a bond, just as you did in the, in her co-defendant's case. She does not, I do not see, I see she had 2 failures to appear in 2020, but I do not see a relatively violent conviction history. I know she has some juvenile history, but I ask that you stay consistent with your setting a bond with her co-defendant, as she was the, I want to say the main defendant in that case, in this case.
Your Honor, the defense kind of touched on part of state's concern is the 2 failures to appear that were both recent. And she also touched on the juvenile history. Ms. Tanis is only 19, so the juvenile history is still significant history and would be put on a score sheet given that this is a felony. So it would all still count.
Yeah, Counselor, your client and the other one are not similarly situated. The other defendant had no criminal history at all. Your client does have criminal history. Your client also has prior failures to appear, which the other defendant did not have. In the other case, we actually had a hearing with witnesses and
Correct, Your Honor. I just wanted to.
we don't have that today.
To your attention. Normally I don't argue the PBLs, but I want to bring it to your attention.
Did you note what I set that bond, what amount I set? Do you have any idea?
No, Your Honor.
I'm sorry?
50,000.
And what was that charge?
For the previous defendant?
Yes.
The burglary of assault.
She had a burg bat, and then she had, I believe, 2 other charges, I think. Didn't she have additional charges?
I thought so too.
I had more than one charge.
She did.
I think it was brandishing a firearm in the parking lot, maybe, was one of them.
That could be.
I don't recall.
She had burglary of dwelling with assault battery, false imprisonment, aggravated assault with a firearm, and battery.
Thank you.
So it was 50,000, 5,000, 5,000, and 100. He said.
Thank you.
I would just point to the fact that it appears she did more than my client did. So I just ask that even if you set a higher bond amount for the 2 failures to appear, that you do set a bond amount in this.
Your Honor, state would contend otherwise. The main battery in this case, even though Ms. Vigilance entered first, she was followed by the other suspects, and Ms. Vigilance immediately started attacking her, and Ms. Yannick, or Ms. Tanis, was allegedly holding her hair and holding her down and pulling it while Ms. Vigilance was otherwise attacking her. So I believe it was pretty much a joint effort. I believe Ms. Tanis was also seen in the video and identified by the video and identified by all the witnesses.
She was. Can we just bring her back at the end? We just have like 3 other people. I have to think about that one. Thank you. Please tell me your name. 21 CF 9137. You're here charged with possession of methamphetamine and possession of drug paraphernalia. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000 on count 1, 100 on count 2. You're not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
And Your Honor, I'd ask that you consider the fact that even there, they had to Baker Act him when considering the out on bond case.
They didn't make it this time. Also, they didn't.
What says the state?
Your Honor, I'm looking at that case. The burg dwelling is all we filed on that case in F2. And I don't see any notices of potential incompetence or anything in that case. So state would ask that you revoke.
All right, I am inclined to revoke it.
And I would just argue that he has 0 failures to appear, Your Honor. The only thing that I see in his history that he's ever been convicted of was the DUI. Here. And it looks like he was out on pretrial release. I would just ask that if you are inclined to revoke, that you revoke and set an actual bond amount in that case.
in the probable cause affidavit, it says that the white male wearing a white t-shirt and light colored shorts was going from residence to residence checking doorknobs. And then she observed the white male enter the backyard area. And the out on bond case is a burglary, and that's
Okay.
really close to it.
I understand.
So I'm going to revoke it, but your office can file a motion.
And we are appointed, correct?
Yes. I'll make sure to appoint in both cases. All right. Good luck, sir. I revoked your bond in your out on bond case. I'm sorry? It means you can't bond out at this time. You're going to be held at no bond until your attorney files a motion in front of the trial judge. Yes. Please tell me your name.
My name is Louis James Woodson, birthday August 25th, 1988. Hey, Miss Elizabeth, may I ask you a question?
You can ask me anything you want, but I need to make sure that you understand that everything you say is being recorded and can be used against you later. Do you understand that, sir?
Yes, ma'am. Yes, ma'am.
I'm going to appoint an attorney to represent you. Would you like to ask your attorney the question?
Your Honor, he's being seen here today for.
Wait, can you get closer to the microphone? You, Ms. George, I can't hear you.
Your Honor, could you tell him what he's being seen here today for?
Yes, in 21 CF 9133, you're here charged with possession of cocaine and resisting an officer without violence.
Okay.
There is probable cause.
I was looking at the wrong one. What is it?
Okay, those are your two charges. There is probable cause for them.
Okay. Can I just? Your Honor? Your Honor, I would ask that on his out on bond case, he would like you to know that he does have a daughter that he's taking care of currently, so.
And she's handicapped, and my auntie's out of town right now. I apologize. My auntie's out of town right now. She's not coming back from the Bahamas for the next 2 weeks. And I really need to be there with her. I really need to be there with her because she literally has asthma attack. She have anxiety attacks, all type of. I really need to be there with her bad. I've been crying all night. I talked to her last night. She's 10 years old, but all she knows is me, and I'm scared to just leave her out there. You feel me? Her mom is getting out of prison in probably like the next 3 months. But right now, I'm begging you to please.
All right, let me address the cocaine case. Your bond is $1,000 on count 1, $100 on count 2. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers.
Yes, ma'am. Yes, ma'am.
Who is Lewis Woodson to you? Oh, no, that's you. Who's the other person? Sasha Thompson. Who is that? Is she a friend of yours?
She was supposed to be taking me to work.
Don't talk about the facts. Don't talk about.
I don't want to know about the facts of the case. I want to know, because I'm going to order that you can't have contact with her.
I don't, man. It was a spare of a moment that I seen her. I don't care nothing about it.
Okay, so if I say no contact, that's easy for you.
I promise, I don't care nothing about that.
All right, no contact with her. What says the state as to his out on bond case?
Your Honor, I understand his testimony regarding his daughter. However, given the nature of that offense, state would ask that you revoke. His defense counsel filed a motion to reduce bond that was heard on June 2nd of 2021, and that motion was denied by Judge Alvaro. So I believe it's reasonable given the ongoing nature of this offense. I believe it occurred back in 2018. And there have been many motions, many depositions, and many things taken. He is represented by private counsel in that case, I believe is Mr. Bankowitz.
Miss,
State would ask that you revoke, given the charges in that case, and given he picked up a new law while out on bond.
Miss, if I can speak?
Again, you can say anything you want. Just remember, it can be used against you later.
Yes, ma'am, yes,
I would
ma'am.
advise you not talk about the facts of the case. It's a very serious offense.
Yes, ma'am, yes, ma'am. In that case that I've been fighting for the last 3 years, Miss, I promise. They done been throwed it out so many times. I just been sitting in the county because of the coronavirus kept on pushing me back. This case supposed to have been thrown out a long time ago. If the state done tried to throw it out.
The state can do that. Let me ask Ms. May, do you have any notes in your?
The state done tried to throw it
File.
out once on me. They done tried to throw it out, I believe it was Keith White. Yeah.
No, the state has the power to do that at any time. So if they're not doing that, it means they're not.
If I'm not mistaken, the judge told them they need to bring more evidence up, and that's the reason why it never got thrown out. And then I just ended up bonding out anyway. I just bonded out on it.
All right, let me ask the prosecutor, do you have any notes about dropping that case?
No, Your Honor, not a single one. And there was, as I stated, that bond reduction hearing was just denied approximately 2 months ago. Arguably, state gave evidence on why bond should not be reduced at that point. So, no, there are no notes as to that or anything I see on any of the court minutes.
And
All right, Mr. Woodson, at this time, I am going to revoke that bond. You need to call your attorney right away. Listen, he can file a motion in front of the trial judge, but a condition of being out on bond is you can't get arrested for any new law violations.
Man.
So you need to talk to your attorney.
it's hard to get I might not ever get another bond on that.
You can, but your attorney has to file a motion.
Miss,
Good luck.
is it-
Good luck, sir.
I'm gonna ask the lady.
Good luck, sir. Wait, who's Cynthia Willis? Where's Cynthia Willis?
Oh, I'm sorry, she refused not.
Oh, 21 CF 1268.
Katie was previously appointed.
ED's appointed. It's a capious no bond. I find her refusal a willing waiver of her appearance today. Ms. Tanis?
Yes, ma'am.
All right, this is 21 CF 8323. I've considered the arguments of both attorneys. Ms. George, as I stated before, your client is not similarly situated to the other defendant in this case. She's older. She has a criminal history. She has 2 prior failures to appear. However, because they were involved in the same crime, I am inclined to set a bond. Your bond is $150,000. You can have no contact with the victim in this case or any co-defendant or any witness. Do you understand what no contact means? You have to answer out loud.
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't be within 1,000 feet of the victim's residence or school or place of employment. Do you understand that?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. Did I say that?
Yes, Your Honor.
All right, are there any other conditions the state would request?
No, Your Honor.
All right, good luck.